Hello, hello, all you legal snacks. Welcome to Legalbytes. If you're new here, my name is Alita. I am a lawyer licensed in California and DC. And on this channel, we explain the law one bite at a time. So I know all of my social media stuff about this live stream said that Nate would be here. So here is the new Nate.
100% whiter than Nate, yes. But it's good to see you all. And, welcome. We're going to have fun here today.
Yeah, I think so. We've got some very interesting. It's been a very interesting series of events that have been going on. Of course, I mean, I feel like we've been on this roller coaster since early November, right? Like it's like ever since Rittenhouse, it's just been like tons of fireworks everywhere. So we've had a lot to talk about.
but first, we need to talk about something, Alita. But first is, how do you feel right now? Because I hear that raspiness. Are you all right?
I'm definitely on the mend, and I had so for anybody that doesn't know, I do have the coof, unfortunately.
No, drop from the stream. No.
I know. I do unfortunately have it. But it's funny because it's like we got to the States, and I will say, I said this on Twitter, I'm fully vaccinated, I'm boosted. I know that a lot of our viewers are kind of against the juice, you could say. But whatever, like we all can make our own decisions about our health, right? Like, so that's the decision that I made. I have my reasons for it. So, I'm assuming, it may not be the case, but I'm assuming that my symptoms are relatively mild because of that. It may not be the case. I don't know. I'm not a doctor. I'm a lawyer. My expertise is in the law. But my symptoms.
And that'll keep your channel monetized.
Yeah, for all you YouTube overlords that may or may not be watching. So, but I mean, yeah, my symptoms have been super mild. I literally tried to avoid family that had COVID, much to my parents' dismay during Christmas. But it ended up getting me. And then it's been kind of nice because, my parents have been otherwise in quarantine. So I was able to spend more time with my folks. So we're like watching, movies at night together. We had like a Ryan Reynolds night the other night. And like, so it's just like, it's not bad. It's not bad. It's a head cold is what I've got. And it's all getting better. So, yeah. But you said your whole family's been getting sick too.
So my whole family, and it was actually a funny story because my brother and sister-in-law, they're doing the, 2 Christmases thing where they go to her family and then my family's, but her family is in Atlanta. So not only did everybody get into this Atlanta shindig, well, of course they got on a plane. So, RIP those people on the plane, but, they got back to Miami, and my brother, all he did was run out to the car and swap presents with them. But that was enough for him to get positive. So now my brother's positive. The only person who doesn't have it is my mom, who has now survived too. And it's really, really, really insane. And some of the people at the event they were at, here's the interesting thing, which, once again, not a doctor, but at that shindig, there were people who were all sorts of political spectrum. Some people who are juiced and some people who are unjuiced. All of them are feeling the same symptoms. So that's how, when I say, I know people that are, so who knows, right? Who knows? I'm not a doctor, right? Yeah. So it's very interesting. But what I do know is this is certainly affecting the economy, and it's certainly affecting institutions. When these flights are canceled, they announced a lot of flights being canceled. Yeah. That is certainly not because of weather. It's because of a lot of the pilots getting the
Rona. Yeah. When I was on the phone with or on hold, I should say, with American Express, trying to change over my flight. That was fun. A fun like 4 or 5 hours sitting on hold, and then finally getting a call back from them at like 1:30 in the morning to get things like shifted over, because they're like, we're under attack, because everybody's trying to change their plans, I guess. Seemingly. Thank goodness it didn't cost me anything to change over my tickets, but so I'm just kind of sitting and hanging out.
Shout out to whatever.
and I've got my work here, so so it's fine. It's fine. I can continue working.
How good is it to have so I have a question. There's a practical question. Like, how much did you bring with you of your YouTube equipment? Did you bring everything or some things, or what?
Essentially everything except for my LaMetric counter that's behind me, showing my subscriber count. Basically,
you got that from Emily D. Baker, right? Did Emily D. Baker hook you up? Yeah.
Yeah, exactly. She didn't get it for me, but she
I
did ask her. Yeah, I did ask her, where she got it. But yeah, I'm recording with my DSLR camera. I've got, my Shure mic. I've got the mini boom mic that, hooks up to the table. And then I've got my two pieces of lighting. Like, I've got everything. It all fits, thankfully, into one carry-on. But it's the reason why my suitcase is overweight.
Yeah.
And I had to explain to Mr. Bites. I've got my whole job here.
That's my problem too. It's always overweight. It's like, oh, why is this bag so heavy? I do YouTube and there's some lights in there.
Yeah, exactly. So, but yeah, I've got to pin the links. So that is that. Thanks, Angry Mailing, for putting those links up. Those are now pinned. But yeah, it's fun. at least where I'm blessed to be doing this kind of work that you can do literally from anywhere in the world, and even when you're traveling,
as we both prove, right? I mean,
yes.
I'll be I'm in Seoul this week. Next week I'll actually be visiting another little town in Korea, so I'm going to bring my portable setup. I do have a different camera. I don't always use my DSLR camera. I sometimes have a webcam that's 4K that Eric Hunley put me on. That's more portable. So I'll be filming from another hotel room. So you guys will get to see an illustrious Korean hotel room once again.
Yes.
Which will be
another
fun. Another one,
one,
right? But I am going to try to work on the background here. I need to get my, I also need to work on my membership stuff, because I totally need toilet paper and bathroom emojis for my chat. I've realized they cannot go without it. And good morning to Andy as well. What's up?
Good morning, Andy. How are you? Andy also has the Rona. So he may have actually given it to me.
Oh, dun, dun, dun.
Who knows? I mean, honestly, it's everywhere. So who knows where I got it? Yep. Seriously. But yeah. So, but yeah, but that's awesome. Actually, so I may ask you offline later about the that little 4K webcam.
Yes, I'll put you on it later.
Okay, cool. We'll talk about it. So anyhow, oh, here's one super chat before we get into some of the more substantive stuff. Here goes my social. TD says, here goes my social credit score. It's not the Omicron variant as the WHO declared. The Xi Jinping variant.
Yeah, exactly. You say it quietly, because literally people are talking about right now how that's the real secret, is that we can't say, the real scary thing is you really can't say the C word, right? And I'm not talking about Rona, I'm talking about China, right? Yeah. Because the second you do that, there's it's like 6 degrees to Kevin Bacon, it's like 2 degrees to China, right? Yeah. So the platform that you're on is connected.
Especially, yeah. I mean, especially being like on YouTube and whatnot, right?
I'm just saying, I'm just saying that, we're not hearing a whole lot about Hong Kong right now. We're not hearing a whole lot about the Uyghurs right now. We're not hearing a whole lot about a lot of stuff that's going on there right now. And they've got, you want to talk about spin. I have Chinese friends, I have Chinese connections. And they tell me the stories that are put out internally in China about Rona, and it's complete propaganda. So, once again, I think sometimes in America, especially the people that, we live in America, we consume American media, we lose sight of the global perspective, which is why I always love talking to you, because you're a person who's outside of the United States, and you also
Yeah.
have a perspective,
Yeah.
as a Lithuanian from, outside of the United States.
I mean, I was born in the States, but yeah, no, I did grow up with that kind of a perspective of like kind of
Mindset.
being in between two worlds, right?
Mm.
Having a strong understanding of that kind of history and that kind of those kind of
Issues.
yeah, exactly, issues. But yeah, I mean, it's true. I mean, for you and me both, like, we're live streaming, we're recording about American laws typically, but then we walk outside the door and go outside and it's like we're not in the United States. So
Yeah, and
it's
it's
a very different world.
It's 2:10 a.m., guys, just so you're not bullshitting right now. So like
You're so
it is,
dedicated.
by the way, Merry New Year's Eve, because that's what time it is
Yay!
right now.
Happy New Year's Eve. D what says stay blessed and healthy. Thank you. And
Thank you.
for the super chat. So yeah, so let's talk about it. Let's Good Logic might be joining us in about an hour. So
do you want to save the jizz for the
yeah,
jizz
I'll leave Gislaine.
Oh, I'm sorry. I'm just illiterate. I just can't pronounce. That totally is not meant to mean anything else.
Of course not. It's definitely not meant to be suggestive of anything.
No.
Also Suffering Succotash says that you need to clean your phone, Legal Mindset.
Listen, man. Do you know what this phone has seen some shit. And this is my American phone, by the way. I'm like a drug dealer. I got two phones. This is the Korea one. This is the American one. The American one is bigger because, well, it's America. Come on.
Oh man. So let's talk about, should we talk about Potter or should we talk about, I keep wanting to say Gretchen Whitmer. It's like, it kind of makes me laugh a little bit that I want to say Gretchen Whitmer, like from Mean Girls. But it's Gretchen Whitmer. Which one? Or Whitmer if you're Fry.
I haven't heard your take on Potter, because I mean this is something that I think I've heard everybody else opine on. I've listened to everybody else complain about it. So I would love to hear your take on Potter, or sorry, the other side, your take on Potter. I'm not gonna do this right. Your take on Potter, because I really haven't heard it. I mean, for me, I'll just say personally, I think this sets a precedent, and I talked about this with the Burlington LAPD shooting. If you haven't seen that video, where
I know people have been talking about it for some reason.
I
still haven't seen it.
So
I know. But I'm quarantined. I'm not going to the Burlington Coat Factory. I'm not worried about that.
You don't, wait, Olivia, you don't normally shop at the Burlington Coat Factory?
Well, I have shopped there before. I'm not going to say that I haven't, but I'm not right now because I'm in quarantine. Because I'm within the 5 days.
Well, are you asymptomatic though?
No.
Okay.
I know. So it actually should be 10 days for me.
Yeah.
I get it.
Be.
I get it. I mean, but
we're not telling anybody. Who knows, really, right? Who's gonna say anything about it?
But also, okay, we'll get into Potter in a second. But also, like, there is a legitimate question that I have, and maybe somebody can answer this that is a little bit more familiar with the CDC's guidelines. But that's for, okay, if you're asymptomatic at 5 days, you can go out. But then what if you're asymptomatic at 6 days or 7 days? And let's say you got tested, before you had symptoms or just slightly after you had symptoms, like there's a lot of questions about the timing on that. Like, is it okay then, so long as you're outside of the 5-day window, if you suddenly no longer have symptoms, to be going out? This is a legitimate question that I have. Please, YouTube, don't yeet me for this.
No, I mean
I'm literally asking for clarification.
Yeah. And that's the whole point, though, is that the CDC constantly puts out these things, no context. I mean, for example, for me, coming back, if I test, for example, if I have COVID, it's not clear, and I'm not sure you know this rule because you're international, right? You have to take a PCR test to come back to America. Well, what if you've had it recently, so your PCR is going to show up positive? Can you also, as an alternative, show a proof of recovery? Is that possible?
I don't know, but I hope so. For my own sake.
I hope so too. Does that mean I become a refugee if I have to come back and like my visa expires and I have to come back, but they won't take me? And it's like, well, what? Like, what happens at the end of the day? Should I just go to Mexico first and then just cross the border illegally so I get around the test? I mean, is that what I have to do? I don't know. But on Potter, what I do know is, and this is my beautiful segue here. I hope you appreciate this, people.
Here we go. Yes, I do.
What I do know is I am now questioning every single police shooting and saying, I don't care whether it's a mistake. You have a precedent. You have a precedent that a mistake can be criminal, right? That a mistake can be criminal now. That has been set. That has been set in the United States. So now every mistake, even an innocent mistake, can be criminal. Somebody who clearly thought they were holding a taser was now convicted of criminal negligence, right? So because of that, it's in a situation in which I wouldn't have blinked twice to say this officer in the Burlington case, there was a good shoot. Now it's got me questioning everything. And I do think Potter has a strong case on appeal, but I never like to say, oh yeah, they'll just win on appeal. That's never something that's guaranteed. And the burden shifts. The burden shifts to Potter to prove that, the trial court screwed up. So that's my perspective on it. And I would love to hear yours.
Yeah, I think, well, so keeping in mind that, of course, all of these criminal statutes, criminal law is a state by state area of law, right? So it depends on which state you're in. Some states will be more strict on certain areas of criminal law, and then other states will be a little bit more lenient on certain aspects. So, keeping that in mind, I think that if we're just looking specifically at this jury in the Potter trial and their finding, I think that they misunderstood the law and that they saw themselves as set on the task of interpreting the law, which is not proper. The jury is a finder of fact, not law. The judge is a finder of law. So the law should be sufficiently clear so that the jury doesn't have to do any kind of guesswork or any kind of interpretation of the law when they're applying that law to those facts. And I think in this case, there was a jury or a juror, excuse me, who recently spoke out to the media and did a sit down interview with a journalist talking about the jury deliberations and their mindset and their thinking and how they reached the conclusions that they did. And based on that interview, it has further solidified my personal opinion that what they did was they used essentially negligence to convict someone where they should have been using recklessness. And his statements show that they expressly found essentially that there was no recklessness, because I'll show this this article.
Yeah, I haven't done a review of the actual juror's interview. I don't know how long it is or
So it's not it's not a video, but it is here's one article on this. So this is, can you see this here?
Yeah, I got it.
The one thing here is that I don't have double screens, so I'm going to have to do one at a time. So let me know if you don't
you're blinded. Yeah.
Exactly. I know, it's like I feel like I'm half blind here. So juror in Kim Potter trial speaks about how jury found ex-officer guilty in Daunte Wright's death. So I can just kind of scroll down here. Okay, so he basically says that, for both counts, he says that he initially found her guilty. And initially for both counts, he said according to him, most of the jurors found her guilty going into the deliberations. So for count one, it was 7 for guilty, and the remainders were either not guilty or didn't know. Then for count 2, 8 said guilty, 2 said not guilty, and 2 didn't know. So it's interesting because, I mean, he, according to him, predominantly guilty. Okay, 7 out of 12. That's just more than half. So there actually was a decent chance that she was maybe going to be acquitted when they were going into deliberations. Based on, just based on that split, and especially for count 2, 8 said guilty, 2 said not guilty, and 2 didn't know. I mean, that's a little bit more, in favor of guilty than anything, but there's still like a decent chance, like if we're talking 12 Angry Men where it was,
Yeah.
11 said to convict and 1 said to acquit, and then he ended up convincing everybody else, it's yeah, so you're saying there's a chance. There was a chance.
Yes, there was a chance.
So the day that we asked the judge what would happen if we reach a decision, or if we can't reach a decision, we were evenly split on manslaughter 1 at 4 guilty, 4 not guilty, and 4 I have no idea, the juror said. So that is especially interesting. It was literally 50-50.
They changed their opinion after that, right?
Yeah. Some people were convinced from guilty, it would seem, to either not guilty or I have no idea. So they were either just completely confused or they started, or they were just convinced otherwise. You know what I mean?
Mm-hmm.
So, okay. And at that point, he says, he or she, the juror said, I mean, we don't know if this is male or female. And at that point, we were just arguing semantics and kind of in circles. The last couple of days, we're literally just focusing on the language of the law, the juror said. The juror also talked about how Potter seemed very upset and apologetic when she took the stand, but said her experience as a police officer came into play.
And once again, this is we talked about this on the stream with Nick, but this is a damned if you do, damned if you don't. The prosecutors are going to make you look like shit if you're unemotional, and they're going to make you look like shit if you are emotional. There's no way you win, no matter what you do.
And also, and the same thing goes with the level of experience too, right? If she's super experienced, then it's like, well, you're very experienced. You shouldn't be making this kind of a mistake. And then if you're inexperienced, it's, well, you're very experienced. What were you doing? Taking on this kind of a role if you weren't experienced enough for it.
Mm-hmm.
So, and this is what he says. I don't want to speak for all the jurors, but I think we believed she was a good person and even believed that she was a good cop. No one felt she was intentional in this. We felt like she was a good person. We felt she made a mistake, and that a mistake does not absolve you from the facts she did commit a crime.
Wow. Okay. See that once again, here's the thing. This is a narrative right there that, and I'm going to say it, and this is my opinion, not a leader's opinion, but this is a narrative that's been put out there by the mainstream media. That was put out there by BLM. That was put out there by social activists, right? This exact line, right? Which is, a mistake does not absolve you from the fact that they commit a crime. This is something I even saw in my comments to my videos.
Yeah.
Which tells me this is something that got to them. And I think the length of the trial, the amount of coverage, the amount of politicization on this, I think it got to this jury.
Yeah, I do. I don't know. So the amount of coverage leading up to trial, I would say.
Yes.
Yeah. Cause technically, I am of the opinion that if we don't have evidence that the jury was actually watching TV when they go home every day, we've got to assume that they aren't. As much as that may be naive, I understand that.
Yes, I would view it as naive.
Yeah, I totally recognize that, and I know a lot of other people would too. But I am always going to say, just in the same way that I'm never going to assume guilt just because somebody has been charged with something, or or liability just because somebody has been sued by something. So I'm never going to assume that the jury is doing anything other than what they're supposed to do. Unless there's evidence showing otherwise. Now, of course, that changes when there is evidence showing that, that they have done otherwise. But yeah, no, I do agree. I think that may have played a role, the media's coverage of this leading up to it. Well, hello here, Mr. Uncivil Law. How are you?
Kurt, what's going on, brother?
Happy to have you here.
Busy, but taking a break.
Okay, cool.
Real work to talk about this stuff because it's more interesting.
It's more fun, right?
Trust me, I gotta go back. I gotta go back to zoning laws after this, so that's a hell of a good time.
Oh, good. Well, good. Zoning in Korea.
Not in Korea.
Fun. So we're talking about the Potter juror who spoke to the media. And I know Kurt and I talked about this yesterday too. And with along with Nate on his channel. But yeah, this is it's interesting here because he says that they agreed that she made a mistake and that she didn't intend to do to shoot him, to kill him, to even use her gun, it seems like. So and just looking at the at the law, we can also take a look at what the Minnesota statutes say. Alrighty, let's see. So I will. Let me.
But in nowhere, once again, and the other thing too is they said they were convinced by closing arguments, but I think is telling, because what we're saying is the judge decides the law, the judge indicates the law. But here's the problem: we are being told in the closing arguments what the law was by the prosecution, and they were grossly misstating the law, right?
Yeah.
So here's the issue: is that should we just enact a rule? Here's the rule: neither side gets to say anything about the law. The only thing you can do is argue the evidence presented, right? And that's it, right? I mean, just the evidence presented, what's there, and maybe some argument, that is based on that, right?
Well,
I know Kurt's.
I don't know that I would agree with that.
I'll go one step, maybe more. How about instead of asking the juror for the end line conclusion, how about we ask them for the steps along the way? Instead of saying, is your verdict guilty or not guilty? Because they're the trier of fact, right? And the conclusions of law are the conclusions of law, right? So, I mean, strictly speaking, there's nothing wrong with asking the juror, do you find this fact? Do you find this fact? Do you find this fact? Do you find fact? And just don't ask them the overarching conclusion, because the overarching conclusion flows from the facts. They're the deciders of facts. So if they find all the requisite facts, guilty, that's the legal conclusion. If not guilty is the legal conclusion. So why do you ask them for why do you ask them for the bottom line conclusion when all they're really supposed to find is all the things leading up to the bottom line conclusion? You're asking them completely the wrong question. How about that?
Yeah, I think the way that, but I think that's how you should be doing a closing argument. And to be fair, I actually did not see the closing arguments in this. To be totally clear, so that everybody knows, I didn't have a chance to watch the closing arguments because I think they were going on when I was at a wedding. But
the wedding was more important. Yeah,
of course it was.
Get the little earpiece in, do the old school walk-in thing of the church.
Were you yelling prenup in the from the aisle?
It might be a little late for that. Prenup. Yeah, there's your legal question for the day. If you sign the prenup just before the certificate, but after the wedding, does it still bind? These are questions that we don't want to raise questions to. Yeah.
But I think most people are signing the certificate ahead of time, though, right? They're usually doing it a couple days before, at least.
I don't know. At least the weddings I've always been at, it's always been after the fact. But I mean, it's been immediately after the fact, but still.
Interesting legal
Maybe
question.
it's the way they roll on my side of the coast. I don't know.
Yeah. So, but getting back to the closing argument, though, I mean, that's really the best way to set up your closing, though, right? Is to go fact by fact to say, if you find this, you find this, you find this, you find this.
Right.
Then
we just need some flow charts.
That's what all of this means together.
Give the damn jury a flow chart.
But not anymore. Because see, here's the problem. Because we're not doing Kurt's idea, which by the way, I agree with. I think it's a brilliant idea. But because we're not in the world of Kurt, because Kurt is not the dictator of all that is legal procedure, unfortunately, we're in a world where now, because once again, winning strategies will be incentivized.
Yes.
So we are now going to incentivize misstatements of the law. So now every prosecutor is going to be incentivized to just go out there and wildly misstate the law and be uncorrected by it, particularly in the Twin Cities, right?
Well,
particularly
I'd say except for the fact that it's going to be reversed on appeal, but still they get however long that takes for the person to be in prison. So they feel like they get a technical win. So maybe you're right. Maybe there is no disincentive. Because like a year or two from now, I'll be reversed by the Court of Appeals. But what do I care, baby? Maybe that's the rationale.
A year or two from now, people won't care as much about it.
Yeah. So there's abuse there, and I have absolute immunity for my misdeeds. So yeah, my answer is looking better. I mean, we agree as a matter of law that jurors have the power, but not the right, to nullify verdicts. They have the power in so much as they can't be stopped, but they don't have the right to. So if we take that away from the jury, we are actually not depriving anyone of any due process. It's like, just tell us what the facts are, and we'll tell you the legal conclusion. That's what your role is. You tell us the facts. We'll tell you what the legal result is. Do you find this? Do you find this? Do you find this? And great. Now just find the flow chart. Just pencil in the end result.
But I would say though that a jury can handle that though. A jury can handle being given the flow chart, and then this is the result that you need to find.
Our entire system is backwards. I'm just saying, our entire system is backwards because even on appeal, we start asking things like, well, a reasonable juror could have found the following things. Like, why not just simply ask them? They're right there. We could have a chart. We could have a sheet. We could have, do you find these things? Why speculate?
And I think that's more within the capacity of an ordinary person than deciding what the law is, right? I mean, and coming to a legal conclusion, right? I mean, having to say, okay, well, take all this, we're telling you the law, come to a legal conclusion versus, hey, just find a fact. That's within most people's basic ability.
Now, within our system as we currently know it and love it, I will bring up a point that I brought up yesterday, which is the term Juris Doctor. The word doctor does literally mean teacher. And it is therefore incumbent on every lawyer to be a good teacher. That's one of the things lawyers have to be. They have to be a good teacher to their clients. Yeah. They have to be a good teacher to the jury. They have to be a good teacher to the judge. They have to be a good teacher in all the things, because it's like because especially a lawyer in the case is going to know that case, hopefully, ideally, better than literally anyone else on the face of the earth, including the Chief Justice of the United States, including, your favorite judge of choice. That lawyer should know that case better than anyone else. And so who better to be the teacher than the person who hopefully knows all the things when it comes to this domain? It might be a specialized domain, but that's okay. That's what doctorates do, right? They create doctorates are all about creating a new little universe of knowledge and a little bit of things. So every case is like a new doctorate unto itself, creating new doctorates all the time. And then you just have to teach. You have to teach the panel, which might be the jury, which might be the judges, which might be the court of appeal judges, which might be your law students, whoever. And you have to teach them, and you have to persuade them to grant you this new doctorate in this increasingly interesting metaphor, because I came up with it. Are we buying any of this?
I mean, it is
okay.
true, though.
LegalMindset's nodding in all the right places.
I'm okay with it. And look, I'm just glad you call me a doctor, because I've just always wanted to be.
Yeah, well,
I prefer the term doctor personally.
If you have a lawyer who actually calls themselves doctor, though, run fast, run hard. Don't do that.
Yeah. There's a question in the chat: can defense use a flow chart in closing arguments? You can use all kinds of demonstratives.
You can use PowerPoints if you know how to use PowerPoint.
I oppose PowerPoint. I'd rather break up the flowcharts. I do like what they were doing in the McMichael trial with like the actual like huge sheets and writing them on. I think that's why more persuasive. I oppose PowerPoint. It's the devil.
Crash Mondo says, my main issue with Uncivil's idea is we now potentially put the legal conclusions in the hands of activist judges. Would we really be better off?
No. It's pretty much what he's saying. Under his idea, we pretty much have a jury instruction, which is agreed to, and we kind of fight back and forth over, right? Each side has objections to, and for example, if there's improper jury instructions, that is cause for appeal, right? And we're seeing cases, and we might even see in this case and in other cases where the jury instructions themselves are cause for the case to be overturned and cause for the case to be appealed, right? So if, for example, those blanks were incorrect in Kurt's world, right, they could challenge that, right? There's
nothing for an activist lawyer, there's nothing for an activist judge at a trial level to do, because it's just a flow result from the facts. You're just asking them what are the facts, and you just put them into the computer, which is the judge, and be like, well, this result, there's nothing for them to do. They can't skew the result, because if one of the facts is not there, we all know for a criminal case, you need each and every element. And one of the elements isn't there. I mean, there's nothing for them to do. Well, that element's not important. That's not how that works. On appeal, that's more of a concern, but you're already there on appeal anyway, because there's no jury in appeal. So what are we talking about?
Right.
Yeah. So, okay. Oh yeah,
my brilliance will not be denied.
Add you guys.
No, that probably wasn't the direction you were expecting it to go, Lita. But I like this direction. Direction.
But that's why I
this
love
is why
having
you invite
you guys
me on,
on.
so I take you to new, strange, and interesting places.
I love it. I love it all, because we get some really great discussion here. And I wouldn't have necessarily thought to take it in that direction, but that's why I love having you guys on. So
also, a jury of my peers, they're all idiots. That's the other thing we've learned. They're all idiots, and we're all doomed.
I do love how everybody was like, oh well, Kyle wasn't convicted and he was in a Democratic stronghold. The Arbery's were convicted and they're in a supposedly Republican area, right? But once again, I think those were the exceptions, not the rule. And I think
the Arbery's were convicted because they're guilty as shit.
Exactly. That's more of the point, right? Is that if you're guilty as shit, you're going to be convicted, and if you're innocent as shit, like Kyle, your chance of being exonerated, right, of being acquitted, raise, right? They go up, right? In this case, you're kind of seeing it play per tempo, right? The political tempo of the Twin Cities area held through. generally.
There might be a takeaway lesson of don't be a cop in the Twin Cities. Not that you might have already needed that lesson since they were trying to abolish the police anyway. So why would you want to be a cop here? I don't know.
I think it's loud and clear now.
Yeah, but to be clear though, on the excuse me, on the issues of the law, right? So what the juror basically said here was that the jury agreed that she made a mistake. And he said that a mistake does not absolve you from the fact that she did commit a crime. Now, we would definitely disagree with that, because in order to make a mistake, that would mean that you weren't, well, what he admitted in this was that they all agreed that it wasn't intentional, that she wasn't necessarily conscious of she didn't make a conscious decision, right, to shoot Dante in any way. Maybe her actions were physically conscious, like she consciously drew a weapon thinking that it was something else, but that is a conscious act, but didn't realize what it was that she was drawing, and that they really believe that was an honest mistake. But in order to be convicted, there were two statutes here that were in question. There was Minnesota statute, the manslaughter in the first degree, 609.20, and what we're talking about here is I think section 2, where they're talking about it's in the act of attempting to commit a misdemeanor or gross misdemeanor, or committing a misdemeanor or gross misdemeanor offense with such force and violence that death or great bodily harm to any person was reasonably foreseeable. And basically what we're talking about here specifically, of course, because we're talking about a firearm, is recklessness having to do with a firearm. It doesn't necessarily say it here in this particular statute, but it does say it elsewhere with regard to firearms. And the same thing too with the other statute is that we're talking about culpable negligence, which is not just regular negligence that would be required in a civil lawsuit, but culpable negligence, which is where the person creates an unreasonable risk and consciously takes chances of causing death or great bodily harm to another. And I mean, that is written directly in manslaughter in the second degree, section 609.205. So this is what we're talking about here. And what this juror said was, we agree that it was a mistake. We agree that she didn't need to know, or it wasn't required in order for her to be guilty. It wasn't required for her to know that she even had a gun in her hand in the first place. In other words, she didn't have to realize that she had a gun and consciously disregard that fact.
She does have to, in order to commit a misdemeanor or intentionally attempt.
Yes.
So
and the foreseeability too, I'd say that as well. Like, it's not foreseeable that if you pull a taser, you're going to shoot somebody. So once again, it's just very, very questionable at multiple steps down the chain.
Yeah.
But I think the point that might have been somewhat tangentially alluded to, but we'll make it a little bit more explicit, is that the odds on appeal, as always, are not great. We see avenues of potential, and I think we all kind of agree that the best avenues of potential are in the closing arguments from the prosecution, because they conflate and confuse the legal issues and misstate it over the defense's numerous objections, I would note. So I think the issue is well preserved.
Yeah.
But as Andrew Branca says, appeals are for losers. The default is 2% rate of success. So what we're feeling really optimistic. We might be up to 4%. Whoa.
Yeah.
So
that's why when you were saying it'll be overturned on appeal, I'm like,
did I say that?
You said that just now. Like, I was like, I wouldn't be so confident, but
I think I might maybe I missaid it, or maybe you misheard one or two, but I was saying, so as long as we need to couch this properly in terms of expectations, it's so we're trying to overturn this on appeal, maybe is what I should have said, or something like that. But the odds are not great.
It's better than the standard, right? It's better than 2%. It's like double. Oh, this has double the probability. Oh, that's great. That's 4% or 10%.
We're almost up to 1 in 20, folks. Hey, it's looking great. 1 in 25. Wow.
Oh man. So you're saying there's a chance. Real Ryan locked her lead to bites, diagnosing court cases, amputating, corruption, and lobotomies just for fun. Thanks.
Lobotomies would help.
Ella says, at this point, can we no longer trust juries to apply the law
At this
properly?
point,
I
what
mean,
do you mean? What do you mean at this
But then
point?
judges
That's
wouldn't be
supposed to
that much.
like every point before this.
Hey,
Judges wouldn't be much
well,
better.
hang on now. I'm going to give a little bit of a white pill, right?
All right.
So, we did just have the Kyle Rittenhouse trial. And in my opinion, that was decided correctly. We also had the Ahmaud Arbery trial. And in my opinion, that was also decided correctly. So I think, this is a case where, I mean, and it's easy for us to say, right? Like, I'm just sitting in my chair, and after this live stream, I'm going to turn this off and I'm going to go back to, quarantining the coof, so this doesn't necessarily impact my life the way that this impacts Kim Potter's life. So it's so much easier for me to say, like, well, this is just one decision where the jury got it wrong. We don't like that at all. However, I would say that there are plenty of cases where juries do make the correct decision. They do reach the proper conclusion based on the facts and the law. I think that this was a case where the prosecution really did conflate the law, really did confuse the jury as to the law. They did what Binger and Krause tried to do in the Kyle Rittenhouse trial. Everything okay there, Andrew?
Yeah, I just dropped my mouse.
Oh no.
It was precariously perched.
But I do think that this is one example of where the jury got it wrong. However, it's not representative of every single case out there today.
And it's not necessarily the jury's fault, which is part of our problem.
Yes.
We think that there's a pretty decent chance the jury was misled and made the decision based on bad information, which, garbage in, garbage out. So
Yeah. And you can only do the best you can with the information you get, right? Because they're supposed to only look at that information. They're not supposed to be looking at anything else. Once again, I love your optimism, and that's why I like doing streams with you, Alita, because you're way more optimistic about humanity than I am.
Some would say naive.
Yes. I will say that I have zero faith that anybody. Look, my whole thing is, how many people can tune away from their phones for a day, even? Right. And you're telling me that you don't get a news pop-ups on your phone. You're telling me that you don't get updates on your social media. You're telling me that people aren't checking their social media.
Yeah.
I just, it's hard for me to believe in 2021.
Yeah.
No, get my mom. She doesn't have a cell phone. She doesn't believe in it. Get her to be on the jury.
How many juries has your mom been on, Kurt?
No, the buys away now.
There you go.
Crash Mono says, thanks for clarifying. That makes much more sense. On a related side note, can you guys go over what negligent homicide is and how Potter's case would stand against that charge? Does Minnesota even have that?
No.
See, it depends what you define as negligent homicide. It's like, are you qualifying one of the manslaughter charges? Is manslaughter, is reckless manslaughter to you negligent homicide, right?
Yeah.
Like, people use these colloquial terms. Sometimes the colloquial terms don't match up with the statutes.
Yeah.
So we need to be specific.
I would say, and I can share the other statute.
Yeah, I think that this one they're using like that second degree manslaughter. I think New York does have a criminally negligent homicide as a separate charge, which might be roughly equivalent to. So different states use different names for some concepts.
So here is manslaughter in the second degree. If you can see number one, I'll try to zoom in here. Can you guys see that? Okay. Oh, whoops. Too far. Okay. So a person who causes the death of another by any of the following means is guilty of manslaughter in the second degree. And number one here is by the person's culpable negligence, whereby the person creates an unreasonable risk and consciously takes chances of causing death or great bodily harm to another. And that was the second charge for Kim Potter in this case. It uses the word negligence, but it's culpable negligence, and it goes on to specify it's where somebody has created an unreasonable risk and consciously takes chances of causing death or great bodily harm.
I think the word whereby here is not doing anyone favors, because what it seems to be is basically a definition section. Person's culpable negligence defined to be. This is what we define it to be. Person unreasonable risk and consciously takes chances. So the words culpable negligence here are just a label, it seems to me, rather than a term unto themselves. Yeah. So that's not in any way misleading.
Yeah.
Even without that, though, you've got two things: unreasonable risk, right, and consciously, right, and that's the thing that just blows my mind. So you're telling me that consciously, what does that word mean to people? Even simpletons should be able to understand consciously, right? Like, That means you use your brain and you know you're doing it, right? It's not an unconscious movement, right? I mean, and this was something she didn't do consciously.
A conscious mistake.
Yeah. Consciously taking a certain chance. That's saying, you know, I see that the speed limit is 25 and I'm going to go 60. That's consciously taking a chance. And of causing death or great bodily harm because you're operating heavy machinery while you're doing it. You know, at the same time, you know, you can say, well, I had a few beers and I'm going to go drive home. It's fine. I know there's a risk, but I'll be fine. That's consciously taking a risk.
Yes.
Of causing great death, causing death or great bodily harm to another. So like that's how you get manslaughter too in these other sorts of cases.
I like how spring gun is in section 3. It brings a warmness to my heart.
Spring gun. Fun times.
That's like a law school problem right there.
Yep. Exactly.
I always was a little mad by that. I was like, why can't I set up traps in my house like Home Alone? Like, you know, I mean, just so they happen to be deadly, like, come on, they're in my home, you know, get out.
That's a good question. I never really thought about the implications of the traps in versus spring gun and for the robbers. Yeah, I think Kevin McAllister is guilty of all kinds of problems there.
We could, you know what? We should do this next Christmas. We should have a live stream where we go over several different scenes to say, okay, how many crimes has he committed here?
Is there an assumption of risk at some point because the bank keep going? Is that a thing that pops into the analysis at some point?
Coming to the nuisance.
Interesting. Coming to the I guess so. Maybe. I don't know. We should watch it and analyze it. Kirby Slayer says they made a moral choice in a legal case. Perhaps all juries should face debriefs with the ever increasing risk of political actors getting.
I would never trust anything they said in debrief anyway. I'm not 100% sure I believe this. Which is one of the reasons that we did exclude it from being available in appeal. Yeah. But I because people rationalize their decisions all kinds of ways. People make it, and I'm not immune to this problem, but people make decisions emotionally and then rationalize it logically. Yeah, it's like, well, here's a logical reason, so it must have been that reason as opposed to the emotional reason.
I know it's crazy that we're not purely logical people, but that's just not how most people operate.
It's disappointing.
Yeah. Forever Cuber, the interview says the interview with one of the jury members, which brought to light the jury seemingly having trouble with the jury instructions. It's unfortunate this cannot be used in her appeal, or can it? Love you guys. Love you too. Thank you. I probably not.
Now, this is a point we never really addressed yesterday because we went off topic, but there was a super chat yesterday along the lines of we should find a way to make law clearer or more understandable to jurors, and I'm not sure that's possible. And the reason is because the reason laws come kind of into play over the years is by basically case after case after case trying to find the boundaries between a thing. So you create a line between any two concepts, like murder. We'll just pick an easy one, like what should be murder and what shouldn't be murder. So it's like, okay, we're going to draw the line here, and then here's what happened basically over the course of the last 1,000 years. There was a case. And the case was on one side of the line or the other, as the case happened to be. And everyone collectively decided it shouldn't be because that was a bad result. And so then we made a deviation in the line. We moved the line. We made a deviation in the line. We put a zag in the line, right? And so over the years, all these results have changed this. And then, of course, the line itself gets a little bit fuzzy because the boundaries are now unspecified because every time you make a new segment in the line, you created 2 new lines, right? So if you put a dot in the middle, it's like now you have 2 lines. So you've multiplied your problems.
Or even you could say that the line started off like a very thick block line, and that over time it just got narrowed and narrowed and narrowed until it became a tiny little sliver. And you have to figure out, does this case fall on this side of the sliver or on this side of the sliver?
Yeah. So I don't know there's a way to drastically to re-simplify. The reason the jury instructions are the way they are is because there was a case. You may not be able to identify the case. I may not be able to tell you what the case, but those are model jury instructions. The model jury instructions came to play in being because there was a case one time or 2 or 3 or 4 times where it went up to appeal and the instruction was honed over and maybe eventually adopted by a legislature or something. It's like there was a long slog of that coming to place. It's like, we need this to deal with all these contingencies. And then you just wind up with a complicated mess. So you can't simplify it anymore because the simplification can't address all the complexities that we felt the law requires.
Yeah.
So you either have a system that is complex or a system that is simpler but more unjust. This is the theme of this episode, Justice, from TNG, Star Trek, for those of you who want to play at home, where the planet had the death penalty for everything, and their lines were very, very simple. Wesley Crusher trespassed and broke a fence and trying to catch a football, and they gave him the death penalty. It's like, well, it's a very clean line, but a bit unjust. So, anyways, moving on.
Yeah, no. But that is the truth of the law. I mean, and that's gone back through history. And the reason why you're exactly right. The reason why we look so complicated today is because there was an extreme case. Because that's why we're running these crazy hypos. And as much as I poke fun at, for example, Joe when he goes off on these crazy hypos, but those hypos end up happening. A crazy hypo will end up happening on a long enough time span, right? Within 100 years or 200 years, some crazy shit's going to happen, and that's going to prove the hypo, right? Eventually.
Yeah.
Crash Mono says, maybe my problem is understanding recklessness then. What's really the difference between recklessness and culpable negligence? They sound similar. Well,
for our money, we don't see one.
As the Minnesota statute has defined it, it seems culpable negligence is the term for recklessness. It's the two are basically interchangeable in that statute.
And that's just a drafting fail. Bad on the legislature.
I think so too. I would agree. A lot of the areas where juries get tripped up could be clarified just by better drafting of statutes. I mean,
how long has the model penal code been around? 50 years.
Long time.
Yeah. So it's like these concepts are not exactly yesterday.
Yeah. No, I definitely agree. And I think that, it's like, there's also this idea that lawyers need to write lawyerly, like a statute could be written a bit more straightforward so that anyone can understand it, because I mean, obviously they affect everyone. So shouldn't everyone be able to understand it?
Hold on though. Those aren't just any lawyers. Those are politicians. That's another level.
I know. Those are the government lawyers. The worst ones. I'm kidding, of course. I mean,
you got to pass a law to find out what's in it. That's great.
Nelson Johnson says that the spring gun was only illegal because it was used to protect an unoccupied home. Kevin would be fine because he was in the house. Actually, you might be right.
No, there's a case. No. There was a case. At least I studied in Florida where someone had a spring gun in the home and it was not permitted. So I don't know.
I think. It depends. As always,
I don't believe you because you said Florida. It wasn't a spring alligator. That's the only reason.
It just launched an alligator, and it was really the alligator that did the killing. And by the way, in Florida, you have no responsibility for native wildlife and the deadliness of native wildlife. So
that's how Disney got away with it.
Exactly. And they have a practice of burying the bodies underneath the lake, but we're not going to go there. That's the darker side.
Well, that's the end of today's live stream. No, just kidding. Alex Ayala says, I always thought lawyers are always busy, yet it seems like all of LawTube has
I want this to be my job. I'm doing this as my side hustle and hope it becomes my job.
Yeah, man. We're building businesses here. Thank you very much.
I do have a day job and do other things, but yes, I do appreciate that. It looks like I'm always online.
We've got the multiple streams of income going here. The goal is to be able to rely on this. So anyway, well, let's talk about Gretchen Wieners. And by that I mean
Whitmer. Stop talking about wieners, Alita. I know it's on your mind.
But... it's Mean Girls. She just reminds me of Wiener. Gretchen.
Do you remember that scandal?
Gretchen Wieners in Mean Girls.
Okay.
She's trying to make fetch happen. Kurt's like, whatever, I'm done.
This is all coming back to the FBI had more people involved in it than the actual criminal conspirators. Is that? Yeah. We have. This is pretty fucked up stuff, man.
I have the motion to dismiss. If you guys want to go over it,
let's do it. And the funny thing is, this is not seeing any of the mainstream media right now. It is just literally uncovered that this essentially was so glowy. It was on fire right now, and the FBI is never going to be held accountable.
Why is the FBI trying to kidnap Gretchen Whitmer in particular? Might be a reasonable question. Why her? I mean, there
Interesting.
are 50 governors last time I checked.
There are.
No, but people are saying it right now. It was a set up Trump thing because once again, these people the mainstream media was painting this as a Trump thing, right? They're painting these people as, because this was happening when Trump was president, right? Notice that the Whitmer news died down when Biden's in office, right? This was something that was really big then. Because there were people pushing back against it, and that's what Trump was perceived as doing at the time.
Yeah. All right, let's read this motion to dismiss. Because
Okay,
I've read some stuff in this stuff before, and it definitely raised my eyebrows when I read prior motions. I'm like, the defense might have something. So let's see how it matured into this motion to dismiss.
All right, cool. Let's get into it. Okay, so we're gonna skip right down to the
skip
the legal discussion.
Skip. Yep.
So because it does have some pretty good discussion here about the laws, and it goes through the Supreme Court decisions. Hey, Barry I'm assuming it's Dvorak, like the composer. UCSD represent. Woohoo! So the legal discussion, they do have some really good discussion actually of the Supreme Court decisions here. So they talk about Jacobson v. United States. Let's just go ahead and start reading it. The Supreme Court has long held that government overreaching can constitute entrapment as a matter of law and can provide grounds for vacating a conviction. So basically going into this. Okay, so assuming you guys know the background here, you've got these guys that were apparently part of the Wolverine Watchmen militia group or something, and they were part of an operation that was allegedly going to kidnap Governor Gretchen Whitmer of Michigan in response to her mandating of COVID restrictions, et cetera,
masks, et cetera.
In the state of Michigan. Exactly. People got very frustrated, as many of us know, and at the same time, so they apparently, supposedly, decided to kidnap her, maybe do other things to her, and the FBI was very much involved here. And so the argument here is that this was actually entrapment. So what they're saying here is, so looking at a motion to dismiss. So this is what we have to look at this in with two levels here, right? Is number one, do their arguments make sense? And number two, is this the kind of thing that is proper to dismiss with a motion to dismiss? So in order for this to be proper, we have to basically show that the facts are not just favorable to the defendants here, but basically that there are no facts for the state, for the FBI here, to say that none of these facts could be interpreted in favor of the FBI or of the government. So if there's any kind of gray area at all here, then it's probably going to be denied, even if you think that overall the arguments were good overall legal arguments.
And the fact that we're going to entrapment, because entrapment once again is a defense. So it's saying, if they did it, right, entrapment, since it's a total defense, they're saying, okay, well, if they did it, and applying it in the light most favorable to the FBI in this case, right, in the light most favorable to the FBI, would that defense apply? So yeah, this is very strong based on that standard.
Yeah, exactly. So okay, so let's go in here. So basically what their argument, like I said, is entrapment. They say because the government so this is quoting from Jacobson v. United States. This is the standard from the Supreme Court. The Supreme Court has said, because the government overstepped the line between setting a trap for the unwary innocent and the unwary criminal, and as a matter of law failed to establish that petitioner was independently predisposed to commit the crime for which he was arrested, we reverse the Court of Appeals judgment affirming conviction. Basically saying that where somebody would not have otherwise taken a certain course of action, and where the government was essentially pestering them to do so, that's a case that ultimately is entrapment. It says, when it can be decided as a matter of law, the issue of whether a defendant has been entrapped may be decided by the judge. This is the part that I'm not convinced that this is going to end up getting getting dismissed on this motion, because I think that this is probably the weakest part of this this motion. Is they're basically saying that, you know, they're saying, implying that courts have implied that courts can decide these matters when they can be decided as a matter of law. Sure, they can, but that's a very strong you got to have some very strong reasoning in order to dismiss it by the court before it goes to trial. Courts in the Sixth Circuit have recognized that these aspects of entrapment, and cites United States v. McLernan, discussing how entrapment is established as a matter of law when undisputed evidence demonstrates government agents engaged in conduct which overbore an innocent person's will and induced them to commit an offense they were not disposed to commit.
So I just covered this today, you know, on one of my streams regarding the Veritas stuff with the CNN guy who was just fired because, you know, some people were saying, oh, well, did this lady induce? But you have to remember there's two elements to entrapment, right? Number one is that they're a government agent. And in the case of CNN and Veritas, they were not government agents. But the second is inducement. And inducement is more than solicitation. Inducement is actually convincing them to do it. So, for example, I know I used to associate with a female police officer who was used on the beat. Yes, associate deeply. That was used. Whoa. Well, I mean,
details.
I knew a lot of details about the practice of law and the application of law. And they would send them out there on the beat and arrest people who were prospective Johns. And you might say, well, isn't that entrapment? Well, no, because they were already out there to commit the crime, right? And solicitation alone is not enough. You actually have to induce them and overcome their will. So having to prove that in a motion to dismiss, that they weren't just soliciting them, that they were actually inducing them, that is a high burden.
Is that why you broke up? It was all part of a deep investigation. She was unable to prove it. Is that what happened?
Damn it, Kurt! You're exposing why I'm in Korea. The true reason. The true reason.
Running from the law of love.
Yes.
Are we all a little bit?
Oh man.
Good luck enforcing that prenup.
Oh man. Yeah, no, and that's exactly right. That's what makes this so difficult, is that you have the possibility that if it's not entrapment, it could be solicitation, which is a different legal question, which means that there's still more to analyze here, right? So basically, it's like if this leaves you feeling like there's still maybe more to analyze, then this is gonna be dismissed, or not going to be dismissed. This is going to be overruled. So they say here, entrapment is generally a jury question. However, the court may find the defendant entrapped as a matter of law, where the undisputed evidence, taken in the light most favorable to the government, demonstrates a patently clear absence of predisposition. This is a bit of a high burden for this motion to overcome, even if you feel like ultimately the government may have actually entrapped these guys in this case. In making the relevant inquiries, a court should not choose between conflicting witnesses nor judge credibility. Exactly right. It should reach its conclusions from the evidence, like undisputed testimony of the prosecution's witnesses. Okay, we'll go a little bit further down. In Jacobson, the court considered the circumstances of a defendant who had endured 2.5 years of repeated efforts by 2 government agencies through 5 fictitious organizations and a bogus pen pal to explore petitioner's willingness to break the law by ordering explicit imagery of kiddos through the mail.
Sounds like a lot of stuff. I mean, just on the surface level, that's a lot of investigation.
Yeah, it is. So this is repeated efforts by 2 government agencies. So in this particular case, and I'll kind of summarize a little bit here, but basically here they said this was enough. This was enough for entrapment. It was enough, you know, even though this guy ultimately admitted to ordering some CP through the mail. It was entrapment because he wouldn't have done it if not for getting kind of badgered over months by getting getting, these solicitations to him to order it. It was a Boys Who Love Boys magazine that he apparently ordered. Now, and what's interesting in this particular motion is, even though I think that this motion probably is not going to meet its burden for a motion to dismiss, I think it does sort of set up some interesting arguments for the case overall, because it goes through even the dissent in Jacobson, where Justice O'Connor, if I can find it here.
Do you think it's possible? Here's a question. Do you think it's possible it could meet a summary judgment standard?
Possibly. I mean, yeah, depending on
my other question is this a magazine that in some sense exists, or is this a magazine that was just fabricated by the government? I mean,
the Boys Who Love Boys magazine?
Yeah.
I'm sure that unfortunately, I'm sure that exists.
Okay, fair enough.
Okay.
Yeah, unfortunately.
Ooh.
Yeah.
Ooh, okay.
Makes me wonder, can we go after the people who make the
either.
magazine? I mean, this is my first. It's like, can we go after those people?
Yeah.
Why doesn't the FBI order a copy in the mail and go and work on that, man?
Because they're working at CNN, Kurt.
Thanks. That's
So even the dissent in Jacobson would frown on the government's conduct here. In her dissent in the former case, Justice O'Connor emphasized that the Jacobson defendant had needed no government agent to coax, threaten, or persuade him. No one played on his sympathies, friendship, or suggested that his committing the crime would further a greater good. In fact, no government agent even contacted him face to face. So that's an interesting point here, because in that case, one of the big reasons supposedly for Justice O'Connor to dissent in that case, in finding entrapment, was the fact that she says there was no government agent here. This was because apparently it was the post office was sending this stuff to him. There was no face to face sort of pressure that this guy was facing in order to do the deed that he did. But in this case, in this particular case, in sharp contrast, informants, of course, not only contacted the defendants face to face, but also coaxed, persuaded, cajoled, played on sympathies, cultivated friendships, took advantage of the defendant's financial conditions, and suggested that the offense they proposed would further a greater good. The defendants did not engage in any activity or for profit. Anything they did with respect to the CHSs was based on friendship and admiration, and the CHS's assiduous cultivation of a sense of patriotism and right doing. I mean, this part right here is of course argument. It's not really tied to very specific facts.
Hold on though. There is a fact in there that could be factual. So the second half is, I agree with you on the second half, but that first statement is an objective fact. Do we have evidence on the record that they profited of this? They either did or didn't. I think that's pretty clear cut.
Yeah, I think I think that probably is they do cite to facts later on about how these guys were how CHS was saying, hey, we should kidnap her. Hey, like there needs to be a body taken here, in this kind of a case, and how guys were like, nope, we're not doing that. Nope, we're not doing that. Nope, we're not doing that. And then, eventually somehow that became the plan. So this is an interesting argument so far. In looking at other cases, the Jacobson dissent cited decisions where courts pointed to defendants' evidenced reluctance to engage in criminal activity and the government overcoming that reluctance through repeated inducement as the most important factor. Unsurprisingly, the Jacobson court reviewed earlier decisions to support its conclusion, one such preceding opinion being Sherman v. United States. In Sherman, a government informer met the defendant at a doctor's office as someone who, like the defendant, was being treated for drug addiction. Several chance meetings followed, either at the doctor's office or at the pharmacy, where both men filled their prescriptions from the doctor. From mere greetings, conversation progressed to a discussion of mutual experiences and problems, including their attempts to overcome addiction to narcotics. Finally, the informant asked the defendant if the defendant knew of a good drug source. He asked the defendant to supply him with a source because he was not responding to treatment. From the beginning, the defendant had tried to avoid the issue, and not until after a number of repetitions of the request predicated on the informant's presumed suffering did the defendant finally acquiesce. And so they go on to basically say, like, that's exactly what happened here. They cite to different meetings where they regarding the initial suggestion of wrongdoing and an expression of reluctance on July 7th, 2020, multiple defendants and others were together when someone apparently raised the subject of kidnapping, and someone in the group immediately said they were not cool with offensive kidnapping, while others, including defendants Franks and Harris, echoed this sentiment. This is and I will say this statement right here was probably one of the weaker ones, because of the fact that they say someone apparently raised the subject of kidnapping. They didn't say exactly who, and they aren't able to tie it here specifically to one of the
not cool with
informants.
offensive kidnapping is
But
the most strong-throated denial I've ever seen in my life.
Do they even have the information on who was FBI and who wasn't? Because I mean, once again, a lot of these FBI identities are so protected that it damn well could be that this person was FBI, and they might not know yet.
They do have identities on some of these guys, which they do list specifics and specific individuals here that they now know were informants. But so the fact that they said, and it's not necessarily like, oh, this kills the case, but I think that for me personally, reading this as a motion to dismiss, this starts to add some of that gray area that would lead me to deny this motion to dismiss if I were the judge.
Yeah, and I understand, because, like, for example, I'm imagining this like at a big meeting where, you know, you're at a giant meeting, there's like 100 people there, and somebody in the crowd yells, "Let's kidnap them," and then another guy's like, "Yeah," and both of them happen to be FBI, but you can't really tell who made the statement, right? You know?
Yeah. It could have been you know, just somebody from the crowd. It could have been one of the informants.
Let's kidnap Legalbytes. Yeah, sounds great.
Yeah, exactly. You know. But it does show that you know that these defendants, you know, someone in the group immediately said that they were not cool with offensive kidnapping, while others, including defendant Franks and Harris, echoed this sentiment. So the fact that they're able to say that the defendants here were like, no, we are not going with that. We are not in favor of that. This incident shows that there was no predisposition to kidnap Governor Wieners or anyone else, Governor Whitmer, on July 18th. Whitmer. On July 18th, 2020, at a national militia meeting held by the government, Ty Garbin rebuffed a CHS's suggestion of kidnapping of a public official. Garbin said, "So I think an objective to go for is not the kidnapping."
I just had a great idea.
Yeah.
It's like I'm looking for a government job, so I think what I should be doing is I think I should be going to more of these national militia meetings. I should just bring a stack of resumes for my law enforcement job. Be like, hey, looking for some law enforcement jobs. Just the leader. Here's my resume. I don't know what you're talking about. We hate the FBI. Of course you do. Let me know when you're available. See how that works out.
Makes perfect sense.
Yeah.
3 weeks later, on August 9th, 2020, defendant Daniel Harris told the lead CHS and others, "No snatch and grab. I swear to effing God." That's a pretty strong statement. Ty Garbin even seconded Mr. Harris's repudiation of the notion of kidnapping when he stated kidnapping is just as bad as going to the Capitol. Or going into the Capitol.
That's harsh.
Yeah, it feels a little.
I think they used that one in the 1-6 hearings.
Yeah, little foreshadowing, right? Even FBI Special Agent Impola has testified regarding August 9th, confirming that defendants reacted negatively to the idea of kidnapping. Question, can we call it that all right? And what's the reaction of the group when Adam Fox talks about this idea? I kind of wish, for context, that they had like a couple more statements above, because there's, you know, that I personally feel like there's a little bit of context missing here.
Yeah.
But assuming that that's all proper, we'll continue. Answer: while there was a negative reaction, people were surprised and they didn't take to it kindly. There was a lot of questions being asked. Interesting. After that meeting, later in the evening on August 9th, 2020, Special Agents Chambers and Impola participated in a phone call with CHS Dan and Adam Fox. CHS Dan, right. What do you think about everybody where they're at? Like, definitely divided. Like your plan and all. I mean, we're divided.
FBI versus non-FBI.
I guess, maybe. These defendants had no desire whatsoever to kidnap anyone, yet the government wouldn't drop the idea, and the CHS continued to broach plans, despite official government admonitions barring the suggestion of such plans. Phone calls like the one above represent a mere appetizer. Ooh, I love appetizers. the CHS, yeah, right? This is just the calamari, guys.
I prefer bruschetta, but okay.
Ooh, I love bruschetta.
No, actually, what like the tomato with the cheese and the basil on top. That's really, really nice.
Yeah, of course.
Well, maybe
I'm
like
hungry.
a little meat in there or something.
And I can't go without a good cheese board. I've got a
cheese board,
charcuterie, a charcuterie.
I will dominate some charcuterie. Yeah.
Yeah, but yeah, that's the best way to my heart, honestly. Mr. Bites learned that very early on is like when we sit down, just immediately order a charcuterie board and then we're good. So the CHS's handlers pulled the puppet strings the entire time. On August 28th, CHS Dan asked SA Chambers, "Would you want 2 trips or wait till we get more guys?" as part of his attempts to, quote, get it right for the government. In state court, Impola affirmed his direct role in telling CHSs what to say to people. He told the CHS what to say to Adam Fox. He was communicating with the CHS during the CHS's conversation with Fox. His directions included suggesting that Fox come train at Joe Morrison's property in Munich and urging Fox to do so. So he conceded we were talking about it. We were talking about what he was saying. Interestingly, given SA Chambers' role in directing activities here, and in a company that tweeted about the investigation as explored in earlier findings on October 29th, 2021, Chambers dissolved the company EXE Intel, filing papers with the New Mexico Secretary of State, discussing Chambers' interest in an intelligence company tweeting about the investigation. Interesting. The timing seems more than coincidental, given the issues raised in this case and also presented in the media. The commercial behavior only compounds the overreaching and emotional manipulation and the government strategic planning that ultimately came up short. It bears noting that in an analogous context, one involving an agent's prior coercive schemes, the Sixth Circuit has said evidence related to an agent's tactics and motivations is admissible and that trial courts abuse their discretion in excluding it. The defendants never agreed to the government's kidnapping plan, a repudiation even the government implicitly recognizes. In response to the defendants' rejection of the plot, government agents prompted CHS Dan to propose alternative, less violent property crimes, which have been previously identified to the court. The government and the CHS proposed these ideas in an effort to hang on to something to justify their work. For example, the government suggested the idea of firing rounds into the governor's cottage and sending the shell casings to her. Notably, the government's actors made the first effort to find the address for the cottage, much like the agent in McLernan, where the court found entrapment as a matter of law when the agent initiated the unlawful activity by doing things like telling the defendant to keep his eyes open for possible drug connections.
Yeah, that's way worse than just keeping your eyes open. I mean, it seems like this is pretty egregious, especially if they were the ones who were the first ones to find the address or try to find the address.
Yeah. The defendants put so little thought into the idea of kidnapping the governor that on September 13th, 2020, when the FBI, the CHS, and the defendants reached Elk Rapids in the late evening hours, they failed to find the governor's cottage because they had the wrong address. That correct address was provided by Special Agent Chambers at 10:14 p.m. as people were making their way from Cadillac to Elk Rapids. Special Agent Chambers provided a street number beginning with 7 and ending in 5, and the actual number began with 6 and ended in 5.
Okay.
Okay.
Yeah, the fact that they went there, though, I mean, that doesn't look great for them.
Yeah, I would agree. I mean, the fact that and you can be very much in on the plan and just get the wrong address,
Yeah, because you don't have to actually commit the crime.
Yeah.
Substantial step, right?
Yeah.
Substantial overt step.
Yeah, exactly.
You got in the car with a gun, probably. Yeah. I imagine.
Yeah. The government's ride-along itinerary was lost to this error. Apparently, the FBI and the CHSs had planned to drive their targets to the governor's cottage, so these targets could be captured on a poll cam that had been installed in advance for the purpose of acquiring evidence. None of the targets knew that the government intended to have them actually go to the cottage as a part of the ride-along or enter upon the governor's private property. I mean, I want to know what they did know or what
they think they were doing. That's
exactly.
This next one is pretty damning that the FBI texted them that. I mean,
So the government conceived and controlled every aspect of the alleged plot. On September 5th, 2020, FBI Special Agent Jason Chambers texted CHS Dan, mission is to kill the governor specifically.
So the FBI is the one escalating this. Like it went from kidnap to now kill, right? And they're the ones pushing the escalation.
Yeah.
Doesn't surprise me.
And again, just looking at this objectively, though, I still want to see what the text before and the text afterwards said. Because if there's context above, before these texts that would suggest that this guy's saying like, this might be a good idea, like what exactly are we talking about?
FBI Special Agent Jason Chambers, why do you want to kill the governor?
Yeah. Yeah, or like or right afterwards, if they're like, yes, this is what I've been talking about, like I would like to see the reaction to this tweet too. 3 months after the government proposed kidnapping and 2 months after the defendant's strident repudiation of the idea and a month after the defendant's reiteration of their repudiation, the government's agents continued to push to shape a kidnapping plan, even trying to elevate it to murder.
Yeah.
Yeah, I the thing is I don't see any evidence of repudiation of this text, and I would want to see that personally, just as further bolstering of this argument. But it does look like there was repudiation of the plan, at least in initial stages. I'm wondering how they ended up in this place where they were actually in the car, going to her property, on her property. And like Kurt said, what it was that they thought they were doing there.
It seemed like they acquiesced to something at some point, right? At some point they acquiesced to doing something involving the government.
Yeah. With regard to inducement and persuasion, the government's emotional manipulation abounded. Its approach was persistent and emotional from the outset. Agents and informants used ties related to friendship, being role models, and acting as father figures to develop trust and reliance in the defendants, which that's not necessarily a problem. I mean, according to the Supreme Court, because these they are able to go in and manipulate manipulate ties and whatnot if somebody is already engaged in that behavior. But if they're doing that to induce behavior that's not already going on, that is a different situation.
Exactly. And I think that's what we're increasingly seeing with the FBI.
Yeah. The CHS has used military veterans as informants, having these people pose as patriotic Americans concerned with preserving the principles enshrined in the U.S. Constitution.
I do like that phraseology, though. They're posing as patriotic Americans with concern with principles of enshrining the Constitution. Like that might be bad
because the FBI truly doesn't care about the U.S. Constitution.
Yeah. I know. Examples of these emotional tactics are everywhere in this case. On June 22nd, 2020, an undercover government employee agent texted Adam Fox, "Hey, brother, this is Mark using my girlfriend's account. Elise was talking to your fiance, Amanda, about getting more involved, and Amanda suggested I contact you." Okay. Attachment to motion to from the get-go, the government manufactured ties to loved ones like Fox's fiance to gain acceptance and trust in the group. On July 11th, 2020, CHS Dan reported, "Going good here, just burning rounds, lending out MPX, making friends." Okay. I mean, but again, that on its own is not enough under this area of law. On September 30th, 2020, CHS Dan told Adam Fox that Dan could not afford food or medical care, citing an inability to purchase a pizza that cost less than $6. While Dan received tens of thousands of dollars.
Little Caesars, baby.
$5 hot and ready.
I don't like Little Caesars.
Sam.
I don't like it. Sorry. It's never been good. I talked about this with Nick Ricada. Every time, and maybe it's just the Little Caesars in Southern California or something, but every time that I've gotten it, it has not been hot or ready.
Well, have you never been a hungry college student though? That
of
literally.
Course.
Okay, so what was your alternative for that price range?
Burritos.
That's right.
Southern California burritos.
Yeah, burritos, exactly. You're not getting pizza for that price. You're just not. You can't. It's impossible.
Yeah.
CC's Pizza also has a really good pizza buffet, and that's only like $6 or $7.
Is pretty dang good, but they don't have that in Southern California. They have that. Inside. Yeah, they've got that in the South, which is great. But they don't have that in Southern California, unfortunately. I do like CC's Pizza. Okay, so citing the fact that he couldn't spend money on pizza that cost less than $6. That's pretty indicative of a financial situation there. While Dan received tens of thousands of dollars for his cooperation with the government, sometimes in envelopes filled with cash, he fostered a bond with the defendants by claiming poverty and deprivation. Dan used his untreated hernia as a device to gain sympathy with Fox and others. He claimed that the VA would not provide him proper treatment after his years of combat service in the Army. At the Luther FTX in September, Dan would tell Adam Fox that he was waiting to die. Feeling the emotional pull of such a confession, Adam Fox told Dan that Dan needed to get surgical treatment as a priority over any of the mission plans Dan in his CHS role was pushing.
Oh, that's nice.
That is very
some
empathetic.
Concern for life there. That's nice. Good.
Yeah,
I'm liking the amount of F-bombs in this paragraph I'm seeing. I'm sorry. It's already getting me.
Why don't you read it for us?
Okay, let's let Alita get there.
Okay, the government coordinated and brought unrelated participants, otherwise unknown to one another, together for meetings where government actors would attempt to radicalize them. The meetings at Dublin and Peebles, Ohio, provide pellucid examples. As touched on above, a CHS first raised the specter of kidnapping at the Dublin meeting. At the national, I don't know why national is in quotations, but at the national meeting in Peebles, this CHS attempted to motivate the targets into anger with rousing speeches featuring Antifa, mask mandates, and similar topics. For example, Andy, you want to take this on?
And this right here is why the fuck I'm telling you it's being allowed by DeWine here. Fucking shitface, witface, or whatever her name is, blackface fucking there. Why are we not returning the same measure we're being given? Why are we giving quarter when no quarter is being given? Motherfuckers are going to throw shit at us. Why aren't we throwing shit back? Why are we not fucking... This is why I am saying I agree with you 100%. This has to happen. I agree 100% with you guys. This shit has to fucking happen. Because if not, this shit right here is going to continue to kill us in our back fucking yard.
That was a great dramatic reading.
However,
however, the part that I'm thinking about here is I agree with you guys. I 100% agree with you guys. What are other people saying that he is agreeing with? I mean, maybe he's just saying that and no one actually said anything, and he's raising the level above people's frustrations. Maybe the agreement is people are saying this, like this sucks. The situation that we have right now sucks and things need to change and we need to do something about it. And maybe he was saying, of course, something needs to be done. We need to kidnap her, but again, just for my personal objective analysis of this here, I want to see the context. I want to see what other people said before and after this statement. But that was a beautiful dramatic read.
Thank you. And by the way, is he agreeing with other FBI agents, right? It's like,
right.
I agree with you other guys. Like if you guys have played Mafia, you always agree with your other Mafia. If there's two Mafia members, right? You always agree with them. Like, oh yeah, he's totally right. Oh my God. Yes. The other Mafia member is totally correct in this game, right? I mean, you're trying to win. You're playing to win. I play to win.
Yeah, exactly. Efforts like these at, quote, national meetings came from multiple CHSs and FBI agents who coordinated their work within the meetings to create an atmosphere of crisis and impending social unrest, all in an effort to motivate the targets to work with CHS Dan to join him in his plot to kidnap Governor Whitmer. CHS Dan's and his handlers' efforts to coordinate a group to initiate his attack planning did not bear fruit, however, despite the government's investment of time, money, and manipulation. On September 3rd, 2020, Adam Fox responded to CHS Dan's inquiry as to the CHS's proposal about acting on the governor at Elk Rapids. Fox replied, "No, let's keep that to us, but throw out maybe taking the cap or gunning down Antifa, or even say arresting the governor, or maybe even charging politicians, and then we can float the idea of cops enforcing constitutional laws." Continuing in this vein, on September 7th, 2020, he sent this chat message to CHS Dan. "Listen, our main direction at the moment is prepared for possible bug out plan Ty wanted to do. We need to have that in line set up, make sure the fact that there's no grammatical cues here is just killing me right now. We need to have that in line set up, make sure everyone's prospective families are safe, and then we have our assault." I'm not sure that this one really helps.
Well, what do you, I mean, it does show that their priority, at least the people that are defendants, are saying that the defendants' priority was their families, not on, the emotional priorities overcame this crazy political image that they're trying to paint.
Yeah.
They're trying to paint these people as these crazy, guys who are out there just to get Whitmer, and they're foaming at the mouth and they want to kill somebody. That's the narrative that CNN, that MSNBC, that the Young Turks are pushing. And frankly, it's just not true. These are humans, right? They have complicated motivations, including motivations towards their families, as most other humans have.
Yeah. Yeah. I think maybe, but I still have the question of, and then we have our assault. So
right.
I don't know. I'm still not entirely convinced that this one is, but I see your point. Also, Edgar Allan Yo-Yo says, "Love the daytime show. It's perfect to have on in the background while I ignore my chores."
I better go back to work, actually, but it's been nice talking to you for as long as I could spare.
Hey, uncivil, man. It's been great.
There.
Yeah, it's been wonderful having you here. See you, Kurt.
And I guess one thing, Alita, I want to point out is that it's saying then we have our assault. That in and of itself is not dispositive, because once again, if you're induced to do something, right, you actually can get away, even if you actually do it. If you were induced to do it, it's a defense.
Yeah.
Right.
Yeah, that is true. That is true. That's a good point. I mean, because even in the CP case, right, where you've got the guy that ultimately ordered some imagery through the mail. He did do it, and he didn't have anybody right in front of him to do it. Even in that case, the Supreme Court said this is entrapment. Yeah, so you could have a guy that's just being convinced over time. He's like, all right, like we've got to prioritize these other things, and then we'll do it, but we've got to do this other stuff first. That's definitely possible here. For me, it feels like it's a slightly weaker case for it than if he had, just the entire time, right up until the very end. I don't know. Maybe.
Then they probably wouldn't even have a case, right?
Yeah,
then they wouldn't even be able to bring charges, I don't think, if they didn't actually take any overt act, right?
You're right.
I mean, I don't know. I guess charges can be brought now no matter what, right? But
That's fair. All right. So in a telephone conversation on September 8th, 2020, Fox said, "Listen, this is what I want to do for now, right? Like, I want to do everything we talked about, bro. I really do. I want to fucking follow up on the order. But for now, we've got to do ghosts on it, right? We can't talk about it. We can't. It's ixnay on the planeek." Well, like, even with all our guys, like, I would put her on the back burner in their minds. Okay. So he's saying, okay, I want to follow up on it. We want to do it, but we can't talk about it. Okay. Later in the same call, Fox continued to repudiate Dan's plans, because it's not until next fucking spring or fucking summer. Okay. We know we can't do that until then. Let's put that on the back burner for now. Let's focus on something more tangible for the coming future and everything. What we should do is go with Ty and his bug out plan. Okay. Okay. Adam Fox's priority in September 2020 was to be prepared for what he believed would be a social crisis at the time of the election and to have a plan to retreat to a secure location so that those involved and their families would have a place to go that would be safe and removed from any impending social unrest that could occur. As an aside, while no conspiracy occurred, even if one might be tempted to consider whether a conspiracy existed between anyone and ACHS, the law has long been settled on the point that proof of an agreement between a defendant and a government agent slash informer cannot support a conspiracy charge or conviction. That I believe is a correct assessment of the law. Simply, the government pushed its agenda, ignoring the disapproval of the defendants and their lack of support for the government's suggestions. The government sponsored, coordinated, and produced trainings, such as the one in Cambria, Wisconsin. As a June 22nd, 2020 Facebook announcement posted by CHS proclaimed an FTX cross-train multi-state on July 11th and 12th at a location on Forge Road in Cambria, Wisconsin. This event would include medical, live fire, range, kill house with breach and entry stack, close quarters weapons protection, if time, knife, and hand-to-hand, lunch and dinner Saturday, and breakfast lunch Sunday will be provided. We are a family/community-oriented organization. Kids are welcome. We have a huge pool and activities for them and daycare on site. Guns up, long live the Republic, or you can come the night before and set up camp or drive down early Saturday early, your choice. Bring what you want to run with if you don't have weapons or want to train and run or on something else. We do have plenty, but you have to pay for whatever ammo you run through. The tone of this announcement established a family-oriented, friendly, community-based atmosphere that would build relationships between participants. I mean, it could be interpreted based on the previous paragraph. It could be interpreted as these are guys that are worried about unrest happening elsewhere and want to protect themselves and their families, as opposed to preparing for an offensive attack.
Yeah, exactly. And that's exactly right. And doing an entry, just doing a house entry in and of itself isn't indicative. I mean, that's a basic kind of drill, right? To do an entry, right?
Yeah. I mean, if you think that you're defending yourself, defending your neighbor, I mean, I could see that. Right. While the defendants could not afford to travel to this event, Dan made it easy for them. He paid for the entire trip. He drove and paid for gas and tolls. He paid for rooms and meals. At the direction of agents, he set out to get the defendants to this meeting, no matter the hurdles, a meeting arranged by another CHS. Ooh, that sounds a little bit where we're getting into some entrapment territory here. It definitely sounds like. These CHSs provided all of the military-style training for that weekend in Wisconsin and elsewhere. None of the other participants had the qualifications or specialized knowledge to do so, a fact that held for the trainings in Munich and Luther, Michigan as well. So I think, I think personally at this point, I'm still thinking this motion is likely to be overruled, but I think that this is some interesting evidence here that we are looking at that may actually help their case ultimately in the end.
Yeah. And like I said, I think summary judgment, it's becoming more likely if they're able to validate some of this information with discovery.
Yeah, I think so. But if it goes to trial and that trial gets live streamed, that would be pretty good for us.
It won't, because this is federal, isn't it?
Oh shoot, I think you're right.
Yeah. We might be able to catch the oral argument if it was in the Ninth Circuit.
I know.
Court of Appeals.
Yeah. Okay. Well, anyhow, maybe we'll wait. Hang on. Which district are we in? Oh, Michigan Southern District.
Michigan.
Okay, of course.
Illinois.
Of course. I mean, I was going to say maybe we can get somebody to the courtroom.
Send Joe.
Yeah, send Joe.
It's his new job. He just goes wherever. I mean, he just goes wherever there's a court case.
Oh, exactly. So let's see. Let me find this again. Where were we? We were on page 16. Okay. These trainings help the government succeed in its aim to make the defendants look up to and admire its informants. On September 12th, 2021, as touched on above, Adam Fox exclaimed of CHS's CHS Dan's hernia. We need to get Dan some medical attention. Yeah, his intestines are fucking hanging out. Oh God. He's one of the most level-headed and professional people I've ever met. He's a good teacher. Beyond admiration for its CHSs, the government even bolstered Adam Fox's credibility with others, publicizing an announcement that Fox was the commanding officer of the Michigan 3%ers. This was a complete government fabrication designed to further the government's plan. No one questions that the function of law enforcement is the prevention of crime and the apprehension of criminals. Manifestly, that function does not include the manufacturing of crime. That is correct. While criminal activity may require stealth and strategy to appear in an investigation as necessary weapons in an arsenal of the public officer, a different question presents itself when the criminal design originates with the officials of the government and they implant in the mind of an innocent person the disposition to commit the alleged offense and induce its commission in order that they may prosecute.
That's the thing there, though, real quick, is that they're implanting in the mind the disposition to commit it, right? Yeah. They're getting inside their head and giving them that. And it seems like in this case, based on everything they've done, they seem to at least partially have done that, right? At least partially, assuming these facts are provable and, able to be backed up by evidence.
Yeah. And they say in such circumstances, stealth and strategy become as objectionable police methods as the coerced confession and the unlawful search. Congress could not have intended that its statutes were to be enforced by tempting innocent persons into violations. Yeah. It's increasing. I will say it is increasingly looking like that is what happened here. I mean, of course, now this is a drafting from the defendant's perspective. So it'll be very interesting to see what the response is from the government to this motion to dismiss, because they have a chance to respond, and in fact they have to respond, otherwise the government will grant the dismissal if the state doesn't respond. So it'll be very interesting to read what they have to say. But I mean, so far from what I can see here, this is looking quite a bit like entrapment. At the very least, the defense is doing its job in painting the picture, right? So sorry, were you going to say something?
Oh, no. I agree with you. I'm completely agreeing with you here. This is looking like entrapment so far. But like you said, I mean, the prosecution is going to paint it another way. They're going to paint it as, no, these people were willing all along. And, because they had X and Y goal, because they were anti-government, because they were anti-mandate, right? They already had the requisite state of mind to do this. Now, the difference is, I think here, and the reason why this is entrapment is because what they're being charged with, the issue here is, did they want to kidnap Whitmer, right? Specifically that crime. They're not being tried of, fighting the mask mandates. They're not being tried of general opposition to the federal government, which is perfectly legal, right? They're being tried for committing the crime of attempted kidnapping of Whitmer.
Yeah. Yeah, exactly. And to me, if you say that they were predisposed to having that particular mental state, that they were, anti-government or, et cetera, that's that puts them in no worse of a position than the drug addict at the rehab facility trying to get clean. Not to say that the two are metaphors for one another, right? Like, I'm not saying that these guys are essentially like drug addicts when it comes to politics or anything like that. I'm not trying to make any sort of like comparison like that, but to say that a drug addict, as painted in the case law, a drug addict trying to get clean, who is pushed by an informant to buy drugs for him or to give him a source for buying drugs, has arguably the same or worse starting place than these guys, and so that shouldn't be an argument for why they shouldn't be allowed this defense.
And these guys went even further. I mean, that's the whole point. They did so much here. It wasn't like they just floated the idea and these guys ran with it, because that I would be more, if it was an idea that, for example, had been floating around already and they didn't bring it up, right? So like it was like one of many ideas brought up and then they just kind of pushed it, like that would be a different thing. But this is an issue where they originated the criminal idea. They planted that idea out there. They put that idea out there into other people's heads. And that's the real issue, right? And I think that's what shocks most people in this case is, what is the FBI willing to suggest? Right? If they're willing to do this, are they willing to say, hey, let's, break into the Capitol. Hey, let's do something else. Hey, let's try to, do all sorts of other information, other things. Sorry, bad things.
Yeah. Yeah. And I would say that, because I see in the chat, VSync says not necessarily Legalbytes. The addict was already in the recovery center for the purpose of getting clean. True. But the crime that he was charged for in that case was not drug use. It was drug sales, I think, or, essentially for trafficking drugs. So, which you don't necessarily need to be a user in order to sell or traffic them. Right? Because wasn't that, I haven't seen Breaking Bad.
Yes,
wasn't that one of the big things that he was like, we don't use, we just make it.
Yeah. But once again, it's actually funny because use is less criminalized than the trafficking, right? Trafficking is usually much more severe in terms of punishment.
Right. So I do think that the two are somewhat analogous here, in this kind of a case. So continuing on. So nor are the defendants asking the court to rule based on any government's overreaching here, though defense on that basis may exist. To this point, therefore, it was absolutely clear that the defendant whose predisposition to commit a particular crime was proved beyond a reasonable doubt. Did I read this part already?
Yes.
Okay, I did. Okay. Given the long list of statements the defense has already provided to the court showing a lack of predisposition on the part of the defendants and the separate filings that will address issues like this lack of relevance to the defendant's criminal histories and the government's concentrated assiduous efforts to initiate a scheme and offense, one can hardly say that this investigation did not involve creative activity in italics, on the part of the government. And it involved repeated efforts to overcome the defendant's aversion to the government's plans, condemning government's multiple attempts to overcome the defendant's reluctance. The Sixth Circuit has been clear. No conviction may be had against one who was induced by the government to commit a crime unless the government proves beyond a reasonable doubt that the defendant was predisposed to commit that crime.
So wait a second, there is a burden shift here.
Yeah.
Oh, that actually makes it even stronger.
Yeah. Yeah, I think so too. No conviction may be had. Yeah.
Unless.
Yeah. So I think that they probably need to show make a prima facie showing that there was, which that wouldn't be the case in a motion to dismiss. That would be in the case in chief. So that's another reason why this motion will probably not succeed, but why this actually shows a pretty good possibility for these guys, for these defendants. Yeah, because the government will need to prove beyond a reasonable doubt that the defendant was predisposed to commit that crime. All the evidence here points to that lack of subjective predisposition at the center of the inquiry. This is going to be a very interesting case moving forward. The government cannot disown its informants' actions and their dogged efforts to overcome this lack of predisposition. In Sherman, interestingly, the court commented that although he was not being paid, the informant was an active government informer who had but recently been the instigator of at least 2 other prosecutions. Here, in this case, of course, as Impola has testified to in state court, and as brought up briefly above, CHS Dan, for one, earned over $50,000 for his work as an informant. That's a lot. That's a lot of money.
That's a good amount of money just for narking. I mean, like, yeah, that's a lot.
Yeah. Interestingly, courts willing to grant motions similar to this one have done so even when the defendant was never ready to do the deal today, but still suggested he would do it tomorrow or at some later time. Hey, there you go. That's what I was. That was one of the concerns that I was pointing out, was that he was still kind of saying we can do it later. But courts have found that that's still enough for a showing of entrapment. And in Odish, where the court granted a Rule 29 motion on entrapment grounds, the personal and relationship aspects of the case matched many aspects of the case at hand. The nature of the government's inducement was to prey on the defendant's sense of humor, sense of honor.
Humor, honor, same thing.
same, right? The nature of the government's inducement was to prey on the defendant's sense of honor. He was unwilling to offend the agent, who was perceived to be rich, powerful, and a potential friend, and having repeatedly accepted the agent's hospitality, the defendant was ultimately unable to say no. I mean, yeah, that's pretty
good. And I like the most convincing thing about this is this is actually saying, this paragraph is saying they've granted a motion to dismiss, a similar motion.
Yeah.
So this is saying that procedurally this is okay, because look over here, this motion to dismiss, right? Motions similar to this one. So it's saying motions to dismiss have been granted that are similar, and you're giving me a similar case to read. So, the judge is going to go look at that case, and if the facts line up, then, it's looking pretty good.
Yeah. I think I think this actually is a relatively strong case for these defendants. I'm not gonna lie. Viva's been talking up a storm on this one, and I hadn't really paid as much close attention to it, but I might be paying some more attention moving forward, because this is a very interesting case, and I do think these defendants do have a decent. Now I'm no Lawracle, right? I don't have the same track record as Nate, for example.
Well, I was just actually bemoaning that, is that all of us on the Potter trial had all of our predictions were broken. I mean, I was pretty wrong in some of my past predictions, but Nate was 10 for 10, but then this broke everybody's streak with Potter. I mean, just threw everybody for a loop.
I know. But I think, but that's, that's how we hone our skills, right, on LawTube. But it is true that can also, all of these factors can influence a person in deciding to go along with someone else's plan, right? I mean, this is why, like, we can compare this to the Me Too movement, where they say, someone in a place of power can also convince a woman to do something that she doesn't necessarily otherwise want to do, and she may just be saying okay because of that difference in power and money and in influence, right? So, and I'm not saying broad brushstrokes that always indicates, that something illegal has happened in those kinds of Me Too cases, but that is one of those sort of similar arguments, right? And I think that's an interesting point in this particular case. So the fact that they say that he was ultimately unable to say no because he was poor. This other informant was getting paid $50,000 to basically convince him otherwise. So it's
well, and you've got the agents and the CH. I mean, this is such a tag team, right? Having like the agents and the confidential informants, and it's so many people on this case trying to convince it. And look, if you have three powerful people who have strong personalities in an organization, that is very, very persuasive, especially a small organization. This isn't like we're not talking about this is like the size of a, giant national organization. This isn't, something like a BLM where you're trying to dictate policy for the whole movement across all of the United States, right? That's going to take a substantial number of people, which is why when you see the policy being sufficiently crazy on a national level, you're like, oh, this is something that a lot of people believe, right? This is an organization that could be swayed by three people. Three people could be a significant number in this organization.
Yeah.
We really don't know the scope and the size of this organization, particularly the active members.
And especially the seeming relative positions of authority that they found themselves in too. I mean, this could also be a situation where these are only three guys in an organization if I can talk in an organization of 50 or 100. But if they happen to take up some very strategic roles in that 50 or 100, that can also influence the overall fact pattern.
Right. Because it sounds like you've got a guy that's mentioned rich. They mentioned all this money they're providing. It sounds like you're in an organization where literally like the CFO, the treasurer, and the VP are saying, oh, we all need to do this thing. And they're trying to convict the president. It's like, well, you know.
Yeah. Yeah. Britt Cormier says, LegalMindset, $50K just for narking. Sounds like he did everything from make the blueprint to build the building.
Come on, this is a government job. They throw away $50K on the regular, guys. That's like a Tuesday for them, you know. Standard.
Yeah, yeah. So what are your thoughts on this one now?
I think I actually, after reading this and just assuming that even 50% of this is provable in court, they'll get away. I mean, this is the entrapment. They're going to get away. This is a defense.
Yeah.
I think you are very valid in saying that a motion to dismiss is a high standard. So we should go in with the assumption that the motion to dismiss will be denied. Yeah. However, I think it lays a foundation and sets a mood for this trial.
I agree.
Certainly summary judgment possibility, and certainly trial an even greater possibility. Now, this is federal court. So once we go to trial, I will just bring up the presumption of the federal government winning, right? We saw this in Ghislaine Maxwell, Gislaine. And most federal cases, the feds take the W because the feds have so many resources. They're professionals at testifying. Those agents are going to get up there and they've testified professionally in so many different cases. So they have a huge advantage. I'm not going to lie about that. However, I think if anybody has a shot for an entrapment defense, these guys have a shot.
Yeah, I would definitely agree with that. And yeah, I for sure would agree. And I think that, however, I would say though, that the case law does seem to be very strong in favor of the defendants.
Yes.
So feds typically take the W maybe in federal court, but in this case, I'm not so sure I would bet on them.
So here's an interesting one, because feds don't normally offer great plea deals. They normally offer trash plea deals, right? But in this case, this may be a one, especially if the media stink. If we all work on this and we're putting out media and other people are linking it and retweeting it and we're talking about this, we're getting this part of the discourse, right? We all work together. It's part of the LawTube community. We amplify these messages and saying this is wrong because now I'm passionate about this. I'm like, this is completely wrong, right? And the precedent it would set for allowing the FBI to do things like this is pretty deplorable. So that being said, I think
deplorable.
So I did that intentionally.
Would you say that it is a basket of deplorables?
Yes. But they don't include Jack Murphy because we don't talk about that on your stream because it gets me triple demonetized.
Yeah, I walked into that minefield on one of Rekida's tweets, and I was like, oh, I didn't realize that's what this was.
Watch my video. Watch my video if you ever want to, but keep all children away and your parents far away.
Gosh,
yeah. So, anyways, but the point is that this would set a pretty horrible precedent, and frankly, the media and as any media that's not simping for the FBI right now would have great reason to cover this because this is such a clear case where most common people would say it is wrong for us to be using FBI resources to do this. Remember the whole gun running thing with Mexican cartels, right? Where we accidentally gave them all those guns. Remember how big of a stink that is? This is even worse.
Yeah.
And it's political because it involved the Rona, it involved the election, it involved political figures. And so you're just bringing it to a whole nother level of political divide, and this is just going to cause a whole big stink if it is something that's continued for long.
Well, before we get out of here, because I know that Rekida's got Mr. T coming up on his channel. I do want to touch on Ghislaine Maxwell since we've kind of referenced her a little bit. She was convicted on all but one charge, so she had 6 charges against her. She was convicted on 5 out of the 6. What are your thoughts on that, Andrew?
I covered it on my channel, but the one that she wasn't convicted of was actual enticement. And once again, that they asked a clarifying question on that. It shows that they maybe think that her actions weren't the straw that broke the camel's back with that particular victim to convince them to engage in the acts. But they got her on everything else. I think justice was served. I think she was guilty of it. I've said it before. I think in some cases, frankly, Maxwell is even more culpable than Epstein in some ways, because I think some of these girls, based on the testimony, I think but for Gislaine being there and an adult woman being in the room to normalize this behavior, I think but for that, some of these girls would not have done that. I definitely think that at this point, she's going to spend, regardless of sentencing, she'll spend the rest of her life in prison. I think that's well-deserved. But I think that a lot of people, what they really wanted was to see some other big names, some Prince Andrews, some Bill Clintons, and that is never going to happen. You're never going to see it. So like it or not, this is just going to move on, and we're going to move past that. This is the end of the Epstein saga in terms of what we're going to see for now.
Probably. That's my guess as well. But I do agree. I think that justice was served in this case. And hopefully that this can provide some closure to a lot of the women who were unfortunately involved in this case and who were abused in many, many ways, taken advantage of, etc. And whose lives were changed forever for the worse because of it.
And this is only a fraction of the victims. This is a fraction of the victims, because of course it's hard to locate them. It's hard to identify them. Years have passed. So there are so many more people that were harmed by Jeffrey Epstein and Ghislaine Maxwell that never got their day in court, that never got to speak, right? That are silent right now, or, otherwise just off in their own world because of the damage that was done to them through this trauma that was inflicted upon them by these two criminals, heinous criminals.
Right. Exactly. So, with that, I will, I'm about to update the description here.
Well,
so that
meanwhile, if you want to check us both out, I know that you can check her out at legalbytes.locals.com and myself at legalmindset.locals.com.
Yes.
If you want both of our exclusive information. And of course, you can check out my channel. You guys know me, Legal Mindset. I love you all. And Twitter at The Legal Mindset. I'm almost hit 10K on Twitter, which is, I never really gave a crap about Twitter, but now I care.
It's funny because I remember being really excited about Twitter when Crab Crawler amplified my account, and I had like 300 at the time, and I was like, oh my god, I just doubled my numbers. I was like so excited. And then like the Rittenhouse trial just continued, and then it just kind of blew up from there. And I keep getting people following me, which is just every time I'm like, this is just really cool, because I had never set out to get people to follow me on Twitter. I kind of saw it as a way to sort of like help promote the YouTube channel, and and then also kind of engage with people a bit here and there. But it's just fun. I feel like I have a lot of fun with it on Twitter.
I have a lot of fun, and you did. I loved your travel photos. I think those were good. That actually inspired me. I'm like, I gotta post more random stuff on Twitter. Like just random photos of me doing random shit. I'm not the best about that. But I try to do better.
Yeah.
So hopefully there'll be a New Year's. I think there'll be a New Year's post on Twitter for sure.
Yeah. So anyhow, well, cool. With that, that'll do it for us. Go ahead and check out Nick's channel, where surely he's already started now with Mr. T with Earl Grey. So anyhow, I'll see you guys in the next video. Bye.